Good afternoon, everyone. Welcome to this Chambers webinar, part of our series on property and commercial related matters. The webinar is being recorded. I'm just going to wait a minute or two just to let everybody finish joining, and then we'll get going. Sarah, can I check, are you sharing slides?
Yes, I am. Can you not see them?
No. They were working a minute ago.
I can still see them.
Thanks,
Oh,
Nina.
I can see the Cornerstone Events page as my main screen. Matt, can you see slides? I can't see any slides. I wonder what's gone on there.
I can see I've got the opening slide.
I'm going to leave and join again and see if that makes a difference. Right, I've got slides this time. Welcome everyone to this webinar on which is part of our business and property series of webinars. I am Kuljit Bogle, KC, and I'll be chairing this seminar and speaking along with my two excellent co-speakers, Sarah Salmon and Matthew Feldman, both of whom are members of the Cornerstone Barristers property team. As I say, this webinar is part of a series of webinars that we're hosting, and you'll be able to find details of all of the other webinars in this masterclass series on our website. If you click on the resources tab and then go to events, you'll find details both of events that are coming up, but also recordings and slides from previous events. And it's a great resource to swat up on something that you might want to be finding out some more about. And those resources aren't limited to the property team. There are webinars and resources across all of Chambers practice areas. And so please do have a look at that section of our website and you'll find some great resources there. This webinar is being recorded, and after the recording, the slides and the recording will be sent to those of you that are here. So if any of you need to leave a little bit early or need to dip out or just want to be reminded of some of what we covered, then that recording will be on its way to you once the webinar is complete in the next day or so. It's also something you'll be able to share with colleagues who might have an interest in the area. So please feel free if you'd like to share it with people who are working in this field. We will be using the Q&A function for questions. Although we can't guarantee that we'll get to all of the questions, if you put any questions in the Q&A function, we will follow up with as many of them as we can during the webinar, and indeed if we're able to afterwards. But of course, if you've got something that's more detailed and needs a bit more detailed consideration, then feel free to send us instructions, and the slides with our contact details and the contact details for our clerks are towards the end of this slide pack. So in terms of what we're going to cover, if we could go to the next slide, I'm going to be doing an overview of the Building Safety Act, but on the next slide we've got a summary of the other things that we're going to be covering. And in addition to the overall framework of the legislation, which is what I'm going to be telling you about, as well as some of the background as to why it was enacted for those of you that are perhaps newer to this area, there's some aspects that we're going to explore in greater detail, and these are set out on the slide. So Sarah's going to be looking at principal accountable persons and remediation orders, and then Matt will look at contribution orders and Schedule 8. I'll then end the session with a couple of recent decisions and some other resources and cases to look out for towards the end of the seminar. So if we go to the next slide, the first slide on the key concepts in relation to the Act, what those of you that are familiar with this area will know is that much of the legislation came out of this desire that the government had to ensure that there was a greater number of protections in place for leaseholders. And that's what this Act does. It introduces various protective measures. And it also removes this idea that leaseholders ought to be the first port of call for historical safety defects. And so there's some protections in place in relation to the costs that can be incurred, and we'll be coming on to those in a bit more detail. But in summary, building owners are no longer able to charge qualifying leaseholders for any costs where cladding needs to be removed or remediated. And in the majority of cases, that's in relation to buildings which are over 5 stories tall or 11 meters tall. And qualifying leaseholders also get protection from costs associated with non-cladding defects, as well as the costs of interim measures such as waking watches and the like. So there are some inbuilt safety for leaseholders there. And in addition, residents that live in high-risk buildings are given more say on how their building is kept safe. And the idea is that generally there ought to be an improvement in the standard of buildings. And so those are sort of driving forces behind this legislation being enacted. And in enacting legislation, the government's created 3 new bodies that are going to have involvement in this area. The Building Safety Regulator is part of the Health and Safety Executive, which most of you will be familiar with and deals with other aspects of health and safety, but is now charged with some additional functions relating to building safety and in particular high-risk buildings. We have the National Construction Projects Regulator that's going to oversee a more effective construction products regulatory regime and is intended to lead and coordinate market surveillance and enforcement in this sector across the UK. And then we have the New Homes Ombudsman, and this is a scheme that all developers of new build properties have to sign up to, a New Homes Ombudsman scheme, and it's designed to allow owners of new build homes to escalate complaints to the Ombudsman in order for consideration. So on the next slide, what I've got is a summary of the 6 parts of the Act. And as I say, we're not going to go into every provision in detail. And both Sarah and Matt are going to pick up on some of those details as we go through. But I'm going to, in the next few moments, cover an overview of parts 1 to 4 of the Building Safety Act, and then hand over to Sarah and Matt to cover some of the more interesting aspects in a bit more detail. So on the next slide, we've got a slide in relation to part 2. And part 2 of the Act deals with the Building Safety Regulator and its general functions. Sections 2 to 30, and what the Building Regulator is tasked with is securing the safety of people in or about buildings and improving the standard of buildings. And Schedule 1 of the Act makes various amendments to the Health and Safety at Work Act of 1974. So the regulator has various functions, including providing such assistance and encouragement to relevant persons to facilitate their securing the safety of people in or about higher risk buildings and in relation to building safety risks. And I'll come back to relevant persons in a moment. But the regulator is also tasked with keeping the safety of people under review, as well as keeping the standard of buildings under review. And it's required to provide assistance to persons in the built environment industry and to registered building inspectors. It's to establish a committee on industry competence and a residents panel and prepare a strategic plan on how it proposes to carry out its functions. It's required to produce an annual report, and within 3 years, under Section 21, it's required to produce a report on the cost-benefit analysis of carrying out inspections of the electrical installations in relevant buildings. I imagine that's in connection with how many fires within buildings are start with there being electrical issues or electrical problems with the electrical installation. And then also within 3 years to consider what further provision may be made about stairs, ramps and emergency egress of disabled persons, and also automatic water fire suppression. In addition to all of those factors, the Act defines authorised officers, and they're the officers that are going to be tasked with investigatory powers on behalf of the building safety regulator. And the Act creates various offences in relation to the obstruction or impersonation of those authorised officers. There are also offences created in relation to providing false or misleading information to the regulator, and there is established a voluntary occurrence reporting system. Section 27 deals with information sharing and cooperation, but going back to relevant persons, they're defined in section 4.3. And going back to what relevant persons, the relevance of them is that they are the ones that are required to provide, the building safety regulator is required to provide assistance and encouragement to facilitate their securing of the safety of people in higher risk buildings or in relation to building safety risks. And those are both concepts that are going to be covered during the course of this talk. On the next slide, I have some information about Part 3 of the Building Act. Or rather, makes amendments to Part 3 of the 2022 Act, makes amendments to the Building Act of 1984. And you'll find Part 3 in sections 31 to 60. And what it does is it inserts an amendment to the Building Act in section 120 D to I. And so section 31 introduces a definition of higher risk building, meaning a building that's at least 18 metres in height or has at least 7 stories, or is of a description specified by regulations made by the Secretary of State. And then the other concept that's introduced in section 31, again by amendments made to the Building Act of 1984, is this concept of building safety risk. And you'll see the details of what that means set out on that slide. And the idea is that in relation to higher risk buildings, we've got the higher risk buildings that's set out in the legislation, but in addition to those, the intention is for the Secretary of State to potentially add to that list, and the regulator can make recommendations to the Secretary of State about whether certain other types of buildings ought to be higher risk buildings for the purposes of the Act. And so one of the things that's highlighted in Part 3 of the Act is that if a risk has materialised which would have the potential to cause a major incident, and major incident is defined in the legislation as an incident that results in a significant number of deaths or serious injury to a significant number of people, that the government can act quickly to amend the list of those buildings that are considered to be higher risk buildings. And there's an explanation or a suggestion in the explanatory notes as to the type of thing that the regulator and then the Secretary of State might consider. And the example that they give there is in relation to single-storey buildings. So not the high-rise buildings that we know can be potentially problematic, but the example given is a single-storey building. It's a hypothetical example of where, if it's established that there are certain areas where there is a high risk of flooding, such that there's a concern about structural failure following flooding incidents, then that could be an example of the type of building that's added to the risk of higher risk buildings that would then fall within the ambit of the 2022 Act. So the idea is to give the government some flexibility to add to that definition as and when the need should arise. On the next slide, Part 3 also deals with compliance notices and stop notices. So there are two types of notices that have been created in relation to the offences, and there are offences created for contravention. And it's because the building safety regulator, so this new body that sits within the HSE, is also the building control authority for any higher risk building in England. And so the local authority is no longer responsible for those types of buildings. And Section 38 gives the building safety regulator the ability to allow the building control authority to issue compliance and stop notices. And that's done by making some amendments to the Building Act of 1984. And it's worth noting that in relation to the offences that are created, there are both imprisonable terms available, there are fines available, or both. And then in relation to the ongoing breach, if there is an ongoing breach, there is a fine available for each day on which the default continues after the initial conviction. So there is an incentive built in to ensure that one avoids the need to go down the route of having to consider a conviction. But in the event of a conviction, there is then a built-in incentive to ensure that there is action taken rather than allowing that default to continue. So that's compliance notices and stop notices. In addition to those features, we then move to Part 4 of the Act, which deals principally with higher risk buildings. And this slide and the overview, next slide, has an overview of some of those provisions, which I know others are going to be speaking out about in a bit more detail. And so I'm not going to trespass on that territory. But in relation to building safety risk, very quickly, we have Section 62 that defines building safety risk as being fire, structural failure, or any other prescribed matter. And I just wanted to flag that there is, again, another hypothetical example given in the explanatory notes of how one might have other matters that are prescribed. And the example given there is about climate change and about how changing weather systems might mean that high winds pose a risk to windows of higher risk buildings, which don't relate to their structural integrity. And that if the Secretary of State were to come to the view that there is a risk posed of that type, currently hypothetical, but something that might transpire in future, if he comes to that view, then he or she is required to consult the building safety regulator before making regulations which could prescribe high winds as a new building safety risk. And so again, the legislation's got some inbuilt flexibility to allow additional matters to be dealt with should the need arise. Section 65 defines higher risk buildings, and Section 71 defines the meaning of occupied. And if we go to the next slide, we've got the other part of the summary in relation to Part 4. And in due course, in a moment, Sarah's going to be covering accountable persons and principal accountable persons, and I'll leave that to her and not trespass on that content. But on the next slide, what I have is some more further information about higher risk buildings, just highlighting what I've just said about the definitions. And then we move to another part of Part 4 on the next slide, which deals with determinations. So I'm going to leave Sarah to deal with that slide and go to determinations by the first tier tribunal. And what we have here is the various matters that the first tier tribunal is given jurisdiction in respect of. Applications can be made to the first tier tribunal by accountable persons. Accountable persons are defined in Section 75(3) as a person who holds a legal estate in any part of the common parts, or who claims to hold such an estate, and a person who is under a relevant repairing obligation in relation to any of the common parts. And I know that others are going to be talking about some of the decisions that have come out of the first tier tribunal. On the next slide, there are some reference there to some of the other duties that exist in relation to building safety. And then on the final slide that I'm going to talk about, I've flagged there some enforcement powers that have been created. So the regulator has a duty to enforce Part 4, and as part of that duty can issue compliance notices and what's described as urgent action notices. And again, there are further offences created in the Act. as well as an appeal mechanism. So there is an appeal procedure prescribed or set out in Part 4 in relation to appealing a compliance notice, and those provisions can be found in section 103, and also appeals against any decision of the regulator that's made under Part 4. And so that's a whirlwind tour of some of the provisions of the Building Safety Act of 2022. And I'm going to hand over to Sarah, who's going to talk to you in a bit more detail, first of all, about principal accountable persons.
Thank you, Koljit. Yes, I'm going to look at principal accountable persons mainly, and then remediation orders under the Building Safety Act. So most of you will know, I'm sure, that under the Building Safety Act, you have two concepts. You have accountable persons and you have principal accountable persons. They're provided for in sections 72 and 73 of the Act. An accountable person is defined as a person, obviously in the vast majority of cases, it will be some sort of corporate entity that has a legal estate in possession of any part of the structure and exterior of the high-rise building, or any part of the high-rise building provided for the use, benefit and enjoyment of the residents. And in the Act, that is defined as the common parts. So that may be a freeholder, it may be a long leaseholder. Or it can be the person who does not have a legal interest in the estate, but is under relevant repairing obligations in relation to any of the common parts. So there you're covering things like a right to manage company. So if the lease gives the repairing obligations to somebody, they can be an accountable person. It should be noted that accountable person is about the common parts or repair and maintenance obligations in respect of the common parts. So where a demise within a lease does not extend to the common parts, then the person under that lease who holds that particular part of the demise will not be an accountable person. In terms of accountable persons, there's a number of obligations, but why I'm going to turn to principal accountable persons is because there's more obligations upon a principal accountable person. So an accountable person has what I'll call the duty to assess the building safety risks arising, the duty to manage the building safety risks, to report information to the regulator, so that's the building safety regulator that Koljit's discussed, and to keep and update prescribed information about a high-rise building. The building safety regulator can give compliance notices where it appears that there's a contravention of a relevant requirement by an accountable person, and if any contravention gives rise to the risk of death or serious injury, then an accountable person may also face a criminal prosecution. There may be more than one accountable person in relation to a high-rise building, and if there is more than one, then they must cooperate amongst one another and coordinate between themselves as to their duties and their responsibilities. An accountable person also has to cooperate with any responsible person in respect of duties under the Regulatory Reform Fire Safety Order 2005 as well. So in relation to principal accountable person, if there is only one accountable person in relation to a building, then that will be the principal accountable person as well. The slightly trickier issue is where more than one accountable person also fits the definition within the Act of principal accountable person. So a principal accountable person will be one of the following. It will be an accountable person who holds a legal estate in possession of the relevant parts of the structure and exterior of the building, or the accountable person who does not hold a legal estate in any part of the building, but who is under a repairing obligation in relation to the relevant parts of the structure and exterior of the building. And the relevant parts of the structure and exterior of the building mean the structure and exterior, except to the extent that they are included in the demise of single dwelling or of a business premises. You cannot be a principal accountable person if you are a leaseholder where repairing obligations do not extend to the structure and exterior of the high-rise building. If there is more than one entity that potentially meets the definition of principal accountable person, then the regulator, a person who holds the legal estate in any part of the common parts, or a person who is under a relevant repairing obligation in relation to any of the common parts, may make an application to the tribunal for a determination. Those people may also make an application to the tribunal in relation to accountable persons should they need to. It is really important who the principal accountable person is, because as I've already touched upon, it is that person that is going to have the additional obligations contained within the Building Safety Act. And there are a number of them, but they include to ensure that the building is registered with the regulator before occupation. Failure to do that is a criminal offence. Where a building is already in occupation when the regulatory regime came into force, they had to register in the transitional period. To apply for, within 28 days of being directed to do so by the regulator, a building assessment certificate. Again, it is an offence not to make an application without a reasonable excuse. To display that certificate and other relevant documents in prominent positions in the building, again, that creates a criminal offence if it's not done. To prepare and revise a safety case report containing any assessment of the building's safety risks, as well as other things that it must contain. To give prescribed information to the regulator by a prescribed time and in the specified way. Not everything's been prescribed in relation to that, so it's important to keep an eye on that. If there is more than one accountable person, the PAP has to establish and operate an effective mandatory occurrence reporting system which complies with the prescribed requirements. And there's also things like preparing a resident engagement strategy and to provide a resident or owner with prescribed information on request. But there's a lot of additional duties that the principal accountable person must carry out compared with the accountable person. So what happens if there is more than one person that meets the definition of a principal accountable person? Well, it's my current view, and I know it's shared with some people who instruct me, some of whom are, I think, on this webinar, that the Act itself only envisages having one principal accountable person, even if more than one person meets the definition within the Act. We say that, we take that view because the explanatory notes, paragraph that I've set out there in the slides, says that there should be a clearly defined duty holder. It's all in the singular. There is also the guidance that has been issued by the Health and Safety Executive, which, as it says, sits within the regulator, that each building must have one clearly identifiable accountable person, and that person shall be known as the principal accountable person. Section 73 itself just uses the singular form, and when you look at that in the context of the explanatory notes and the guidance, then the suggestion is the inference must be that there can be only one. In addition, awareness who has what duties under the Act is clearly important and clearly part of what the legislation intended to happen. And if there's more than one principal accountable person, for all the reasons that I've discussed as why all their duties they have, it's very important to know who has what duty and who should be carrying out what. And for that clarity and that awareness, it also seems to me, at least, that the Act envisages one person. The enforcement provisions obviously include possible prosecution, and given the seriousness of enforcement, again, clarity is key. Who has these duties, who is responsible for them, so that there's no oversight as to who is doing what in relation to a high-rise building, and ensuring that it is safe for those that occupy it. So the question then is, what happens if there is more than one? And of course, you can apply to the tribunal under Section 75. for the tribunal to decide who is the principal accountable person. Now, the issue that's cropped up and the reason why I've included this in this talk today is where there is an agreement between principal accountable persons as to who should be the principal accountable person, do you actually need to make an application to the tribunal? In most of the cases that I've been involved with today, what's happened is the application any agreement between the parties, and then after issue, an agreement has been reached, at which point the tribunal has been more than happy to approve a consent order which sets out who the principal accountable person is in relation to a particular building. And that gives the certainty and clarity that I've been discussing. But Judge Sheftel in the Ovington court case, which I've set out there at paragraph 15, essentially said that there is no provision, well, it was said in the case that there was no provision for the parties to agree between themselves, and he doubted that. He says he's not going to make any express findings on this, but he queried whether or not you needed to go to the tribunal where there is an agreement. And of course, you can register yourself as the principal accountable person on the Building Safety Regulators Register. So he queried that, but you'll see in his last sentence, he also sets out that there may be advantages of the parties having certainty and being bound by their agreement. And that's where my view is at the moment, that an application should be made to the court, even if there is an agreement. However, I know that some of my clients are attempting to obtain some clarity on Judge Sheftel's view at the very least, which is of course obiter, to see whether or not the tribunal is going to give any further sort of legal guidance as to what they think should happen. But obviously, if you've got one principal accountable person registered and something goes disastrously wrong and they are prosecuted, and then they actually look at the legislation and go, oh, hold on a minute, there's more than one principal accountable person and we might not actually be the principal accountable person, then it strikes me things can get muddied and confused down the line, and there can still be challenges, which is why at this early stage, if you're dealing with high-rise buildings, just strikes me as a safer approach to go to the tribunal, even if there is an agreement as to who should be the principal accountable person. Now, the last slide in this section isn't really dealing with principal accountable persons as such. It's about service outside the jurisdiction. The reason I've included it in this section is because it's come up in a case that I have dealt with in relation to principal accountable persons. But it strikes me this is the sort of issue that is going to crop up in building safety cases where one of the entities involved does not have a registered correspondence address at Companies House within England and Wales. So the procedure under Section 75 of the Building Safety Act is governed by the 2013 tribunal rules. The tribunal does have case management powers, we know this, and it says in Section 6 of the rules, it says, subject to the provisions of the Tribunal Courts and Enforcement Act 2007 and any other enactment, the tribunal may regulate its own procedure, and the tribunal may give a direction in relation to the conduct or disposal of proceedings at any time, including a direction amending, suspending, or setting aside an earlier direction. And Rule 16 deals with the provision of documents. And it sets out, in particular, that any document to be provided under these rules, a practice direction or a direction, must be sent by prepaid post or document exchange or delivered by hand to the address specified in subparagraph 5. Subparagraph 5 is the address which, for present purposes in discussing this particular slide, in the case of an incorporated company or other body registered in the United Kingdom, the address of the registered or principal office of the company or body, or any alternative address notified by that company or body to the tribunal and all other parties. And in the case of any other person, body or authority, the usual or last known address of that body or authority. And it says in subsection 11 to that rule, the tribunal may waive a requirement under these rules to send or deliver a notice or other document to a person, or make an order for the provision by alternative method, whether by advertisement in a newspaper or otherwise, as the tribunal may think fit if that person is out of the United Kingdom or for any other reason notice or other document cannot be readily sent or delivered to that person in accordance with these rules. Now, there are no express terms within the tribunal rules that deal specifically with service outside of the jurisdiction. Delegates will be aware that there are in the civil procedure rules, that's part 6, which deals with service of documents and practice direction 6b. However, you'll note the case on the slide, the 2014 Upper Tribunal case there, that said that the civil procedure rules do not apply to the tribunals. So what has happened relatively recently, or at least recently in the context of building safety, which is a relatively new area and jurisdiction for the tribunal, is the case of Gray that I've set out on the slide. Now, it's an unreported case, and I've only ever been able to find very short notes on it on Chambers websites that have been involved in that case. But the High Court appeared to hold, and I say appeared to hold because it is unreported and we can only see a note of it, that in a case where a tribunal directed that a party could be served out of the jurisdiction with permission from the High Court could grant an order as if the civil procedure rules applied things. So it's essentially suggesting that because there was no provisional mechanism within the tribunal rules itself for service outside of the jurisdiction, what has to happen is the tribunal has to refer it to the High Court, and the High Court then has to determine it in line with the civil procedure rules. The High Court can then essentially say that service can be affected under the tribunal's direction to someone outside of the jurisdiction. So my first tip in relation to this, because this is what happened when it came up in a case that I dealt with, is even though it might not fall squarely with under where you should serve, an entity may be using other addresses. And in the particular case I was dealing with, its registered address for the purposes of the rules was outside of England and Wales, but actually it had registered itself on the Building Safety Regulator register at an address in England. So the argument was that whilst that isn't its principal or registered address, it was clearly the address it was using for building safety issues. The tribunal agreed, allowed us to use that address under rules 6 and 16 of the tribunal rules rather than heading off to the High Court. And we actually did effect service, and then they did start to engage with the proceedings. So that was the end of the matter. But if you don't have a solution like that, the question really is, can the tribunal use its case management powers, or do you have to go through this sort of convoluted way of affecting service by heading off to getting the direction from the tribunal, heading off to the High Court saying, yes, it complies with the civil procedure rules, you can serve it in line with the tribunal's direction. Whilst I entirely appreciate that the High Court's decision in Gray, even being unreported, is going to be highly persuasive to the tribunal and likely to be adopted, it does seem to me that that approach is counter to the overriding objective, which is Rule 3 of the tribunal rules. And that must be particularly true in circumstances where, in Building Safety Act cases in particular, you will have a lot of freeholders with responsibilities under the Building Safety Act who have addresses outside of the jurisdiction. So it just seems to be a slight anomaly and an unusual sort of hurdle to have to get over, but that is where we are. But do look around and do see if you've got alternatives to going off to the High Court to seek a declaration that service can be effective. So that ends principal accountable persons, at which point I move on to remediation orders. So this is dealt with in Part 5 of the Building Safety Act. And there are a variety of definitions, which I'm simply just not going to have time to go through. But I am assuming that most delegates on the call will have some familiarity with this legislation and will be aware of the definitions. But you'll see the sections are outlined in the slide, so you can go and have a look at what the definitions say. I do just want to touch on relevant landlord, however, because there has been a relatively recent case on this, and it's I'm not going to pronounce it correctly. It's Mirchandani, so Mirchandani against Java Properties International, which was a first-tier tribunal case. And it was one of those cases, one of only one or two cases that I'm aware of where a remediation order has not been made, and it wasn't made because the landlord did not meet the definition of relevant landlord. And what Java, the landlord, argued in that case is it wasn't a relevant landlord for the purposes of section 123 because its management functions had been transferred to the right to manage company. The leaseholder's arguments to the contrary were all rejected by the tribunal, and the tribunal made clear that section 1233 requires the landlord to have a repairing obligation. Describing procedures for returning management functions to a landlord as overly legalistic and cumbersome cannot lead to undermining a statute. Whilst the right to manage company continues to manage the building, the landlord is prohibited from doing so. The argument that the tribunal could make an order if it had jurisdiction to do so on moral arguments alone was not going to get the leaseholders anywhere. Remediation works were a management function, and the purpose of section 123 was to enforce maintenance obligations on those failing to exercise them. And an entity which is prohibited from exercising such functions cannot do that. So Java was not a relevant landlord. The right to manage company, however, was also said not to be a relevant landlord. That's in paragraph 41 of the decision. That's because this particular right to manage company was not a party to the lease in any capacity. It had simply taken over the management functions. The tribunal noted, of course, that where a management company was a party to the lease, that management company could be a relevant landlord. So the first tier tribunal's power to make a remediation order is set out in the regulations that I've put on this slide there. And it is straightforward. The first tier tribunal may, on any application by an interested person, make a remediation order under section 123 of the Act. And I'm just going to flip to the main cases on this now. So where the test has been met, and we've just seen a case, I've just gone through a case where the test wasn't met, so a remediation order wasn't made. Where the test is actually met, I'm finding it extremely difficult. I don't think there's one at the moment case where a remediation order has not been made. I do know there have been cases that have been struck out, but in terms of reported decisions on the First Tier Tribunal's website, I haven't currently been able to find one where the test has been met. It is a discretion. It's been dealt with primarily in the Vista Tower and the Chocolate Box cases, numbers 1 and 2 on there. Both cases rejected the argument that where the test was met, the tribunal had to make a remediation order, but the exercise of discretion was considered. And in Vista Tower, what the tribunal said is we consider the 2022 regulations give the tribunal both a power to and a discretion as to whether to make a remediation order. There were a number of considerations in Vista Tower that the tribunal considered relevant. The facts of the case generally, the tribunal's jurisdiction that is about ensuring that defects are remedied in a responsible fashion, delay, where there's been delay by one party, both parties, other parties, building safety fund applications, if that's relevant, weigh into the balance. They're probably not going to be a decisive factor, but they weigh into the balance, as does potentially forward funding. In this case, however, it's quite an interesting one to sort of start with, because the works were ongoing, and the tribunal said the most obvious reason for not making an order was the fact that the respondent had entered into a JCT works contract with its contractors and a GFA with the applicant, and work had started to remediate the defects at Vista Tower. However, it was still appropriate to make a remediation order. The tribunal wanted to give a backstop, to give reassurance. They said this was not a fault-based order or a case where it should set short deadlines because works had been started, but a remediation order was still made. chocolate box, similar, the nature of the discretion was looked at again, and it was said that Parliament had clearly, by giving the tribunal a discretion, left it up to the expertise of the tribunal. And it relied on Gray, it discussed Gray, and it went on to make a remediation order. The two other cases I've set out there looked at, so the DeBarry case and the Blomfield case looked at the prejudice to the occupiers remaining at the mercy of the respondent living in a building that was unsafe, so that was weighed into the balance, and where a property was unsaleable as well. And also the DeBarry case looked at a respondent being willing to carry out works, but concerns about delay meant the respondent should be bound to a firm timetable. So again, they looked at delay, but in that case felt that it required a firm timetable. I've put a little asterisk near Blomfield there because I'm going to move on to my next slide, realising I'm not giving Matt very long at all to speak. There has been an appeal in the Blomfield case, and it's really recent, and it is well worth a read. I had a case recently before the tribunal. I think it was 2 days before this appeal, well, the date of the judgment of this appeal. It wasn't on the, I don't think it was on the Upper Tribunal's website immediately afterwards, where the tribunal has essentially said that the First Tier Tribunal has essentially said that its direction from up on high is that they just have to make buildings safe, and they can case manage and they can do what they want in order to do that. Monnier Road reminds the tribunal that it should not step into the arena, it should not run the case. And whilst the landlords in that case were content with the remediation order being made, it said it went too far. It was the breadth of the order, so it included things that were not relevant defects. And it also included things that the tribunal had put forward themselves. They were not in the case that was put forward by the leaseholders. And the procedure in the tribunal, when it brought up those matters, meant that that was unfair. So in those circumstances, the order was set aside and the upper tribunal remade the order, but only including relevant defects and none of the additional items. But it is worth a read because it is a reminder about the procedure and the powers of the tribunal and how far they can go. And I'm going to hand over to Matt.
Sarah, thank you very much for that. In the time available, I'm going to be talking about remediation contribution orders under Section 124 of the Building Safety Act, and the prohibitions and limitations on recovery of service charges set out in Schedule 8 of the Act. Now, I should say that this is, as I'm sure you'll be aware, quite a technical area. And in the 10 minutes or so that I have available, I won't be able to go into too much detail, but hope to be able to set out at least the principles involved and touch on the cases that have so far made it into the FTT and beyond. So this will be very much a whistle-stop tour of RCOs and the prohibitions and limitations under Schedule 8. So I think it's probably useful just to start off with the jurisdiction of the FTT. That's set out in Section 124, subsection 1 of the Act. So the First Tier Tribunal may, on the application of an interested person, make a remediation contribution order in relation to a relevant building if it considers it just and equitable to do so. And what does an interested person mean? That has a meaning set out in Section 124, subsection 5. And so if we could just move on to the next slide, if we could. So it includes Secretary of State, the regulator, a local authority, a fire and rescue authority, a person with a legal or equitable interest in the relevant building or any part of it, and any other person prescribed by regulations made by the Secretary of State. Now, just turning back to section 124(1), the issue of whether the first tier tribunal considers it just and equitable to do so, in my view, is likely to give rise to subject matter of determination in the higher courts in the months and years to come. It's clearly it's a wide term, and some guidance has already been given, particularly at triathlon at first instance. But I'm sure we're going to be reading about some more judicial input into what constitutes being just and equitable to make an RCO. Definition of an RCO set out in section 124 subsection 2, remediation contribution order in relation to a relevant building means an order requiring a specified body, corporate or partnership to make payments to a specified person for the purpose of meeting costs incurred or to be incurred in remedying relevant defects or specified relevant defects relating to the relevant building. And the question of specified body, corporate or partnership, that is essentially defined in section 124 subsection 3, and that says that a body, corporate or partnership may be specified only if it is a landlord under a lease of the relevant building or any part of it, a person who was such a landlord at the qualifying time, in this instance 14th of February 2022, a developer in relation to the relevant building, or a person associated with a person within any of the above. And the question of specified body, corporate or partnership, that issue was considered in a case called Battish, which, if time permits, we might have a look at in a few minutes. That was in fact the first RCO that was considered by the FTT back in 2023. And as I say, if time permits, we can look at that in a little bit more detail. So turning to Schedule 8 of the Act, and of course, it'd be well known that sections 117 to 125 and Schedule 8 only apply to relevant buildings, which is defined in section 117 of the Act, and to relevant defects. And relevant defects is set out or defined in section 120 subsection 2. And what that says is that relevant defect in relation to a building means a defect as regards the building that A, arises as a result of anything done or not done, or anything used or not used in connection with relevant works, and B, causes a building safety risk. And under section 122 of the Act, that expressly refers to Schedule 8, which provides that certain service charge amounts relating to relevant defects in a relevant building are not payable, and makes provision for the recovery of those amounts from persons who are landlords under leases of the building or any part of it. If we could just turn to the next slide, which is essentially the definition of relevant works. So that falls under definition under section 120 subsection 3, works related to construction or the conversion of a building if completed in 30 years from the 28th of June 1992. There's obviously the question about limitation, which is very much a topic that's in the courts at the moment, and will no doubt be covered in the Court of Appeal decision of Triathlon in due course. Works undertaken or commissioned by or on behalf of a relevant landlord, if completed in that same 30-year period, and works undertaken after the 28th of June 2022 to remedy a relevant defect. So turning to the next slide, is the lease in question a qualifying lease? So most of the protections apply only to qualifying leases, and one turns to section 119 for the definition of a qualifying lease. For purposes of time, I shan't go through it for now, but the definition is in section 119, and paragraph 13 of Schedule 8 and the 2022 regulations will inform or assist to inform whether a lease is a qualifying lease. So in relation to the position where there is a relevant building and a relevant defect, one has to look very carefully at Schedule 8 to see whether there will be a prohibition on a service charge payable from 28th of June 2022 or a limited contribution from the tenant from the same date. And the prohibitions, again, they're set out in various sections of Schedule 8, various paragraphs there. So paragraph 8, as we've touched on, Courgette mentioned that in the opening talk, that no service charge is payable under a qualifying lease in respect of cladding remediation. Paragraph 4 of Schedule 8, no service charge is payable where the lease is below a certain value, and one can see the value set out at paragraph 4 of Schedule 8. And no service charge is payable in respect of any relevant measure relating to a relevant defect if the relevant landlord is responsible for a relevant defect. That's paragraph 2 of Schedule 8. And paragraphs 3 and paragraph 9 of Schedule 8. So no service charge is payable where the landlord meets the contribution condition at the qualifying time, and in respect of legal or other professional fees relating to the liability or potential liability of any person incurred as a result of a relevant defect. Now that again is the subject matter of a decision that has been and heard by the Court of Appeal, and we're awaiting a determination on that. Very, very briefly, in terms of limitations, again, these are set out in various parts of Schedule 8, paragraphs 5 and 6, sets out the parameters for the values. I shan't go through this in any detail now. I can see that we're at 1 minute to 4, but do have a look at paragraphs 5, 6 and 7 of Schedule 8 in relation to the limitations. And finally, I've set out on the slide, the next slide, I think, what is the case law so far in relation to RCOs. I don't think I'm going to have time to go through these cases, but Battish was the first RCO determined by the FTT. We have Triathlon Homes, which was heard by the Court of Appeal in March of this year, awaiting judgment. And Sarah was talking about the Grey GR Limited remediation case. This is linked to that, but this is in relation to an RCO. And this case was determined 24th of January 2025. But it's understood that the upper tribunal has given the respondent permission to appeal. So we will await the decision of the upper tribunal in due course. And at that point, I think I'll pass back to Courgette, if I may.
Thank you very much, Matt and Sarah. I'm conscious of the time. I'm going to just flag what we have in the remaining slides so that delegates can look at those at their leisure, or if they've got questions about what's on the remaining slides, or indeed anything else that we've covered, feel free to follow up with us afterwards. But on this slide, we have two decisions. They are both of May of this year, so relatively hot off the press, having been handed down last month, and there's a summary of them on this slide. The Supreme Court's decision relates to some remedial works that were carried out by somebody that no longer had a proprietary interest in the development, and it is worth a look at if you or your clients are advising in relation to a situation where they've divested themselves of that interest. In that case, the person that no longer had proprietary interest had actually voluntarily done some works. And the question was whether, when they were sued, whether what their responsibilities and obligations were in relation to that litigation. And that was the Supreme Court case on the left of the slide, and the other case on the right, Wilson and others, relates to a strikeout application made by one of something like 40 leaseholders that are named in this litigation. The strikeout related to some of the heads of claim that had been claimed. Quite interesting to read, actually, in terms of the types of claims that were issued. It was evident that the leaseholder here was an investor with who had looked at things like return on investment and the loss of return on investment, and some of the capital losses and the inability to mortgage the property and losses claimed out of that, many of which were described as being irrecoverable. And so, indeed, one of those heads was described as spurious. So, worth a look at in terms of the ambit of heads of losses that can be covered or included. And then on the last slide, we've got some information about decisions that are expected and have flagged when they've been heard, and that judgments expected shortly. And so those are cases worth looking out for. The property team always tries to do updates and e-flashes in relation to recent developments. And if you'd like to find out more or be added to our mailing list, there is a function on our website whereby you can be added to our mailing list, and you'll receive any e-flashes or communications that we issue in relation to these decisions. And indeed, it allows you to elect any other subject areas or practice areas that you've got an interest in order to receive updates in relation to those. I'm going to just flag that on the last slide, we've got our contact details if there are any matters that you'd like to follow up on, and you will receive a copy of both a link to the recording and a copy of the slides that we've spoken to once those have been prepared and are ready to send out to you. Thank you again for joining us, and do look out for the other webinars that we're doing in this masterclass series. All the details are on our website.